This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Now I have the pleasure of introducing our speakers for today. First, we have Monty McIntyre. He is a mediator, arbitrator, and referee with ADR Services who helps settle cases as a mediator and conducts focused hearings and issues fair and impartial decisions as an arbitrator or referee. Monty handles cases in the areas of business, commercial, employment, insurance, bad faith and coverage, real property and torts, elder abuse, medical malpractice, personal injury, and wrongful death. Monty brings extensive civil trial experience to his work as a neutral, having represented both plaintiffs and defendants in a wide variety of civil cases in the areas listed, mentioned before. Monty has been a member of the American Board of Trial Advocates since 1995, is a past president of the San Diego County Bar Association, and is also a past president of the San Diego chapter of ABOTA. Finally, Monty is the publisher of California Case Summaries, which provides annual practice area, quarterly, and monthly civil case summaries of every new civil case published each year by California courts that can be read in minutes, organized by legal topic with the official case citations. And next, Mike Roberts has been a full-time neutral for the past 30 years. He has served as a mediator and special master in over 4,000 cases with aggregate settlements in excess of $800 million. His mediation practice consists primarily of major financial controversies and complex multi-party matters in the areas of employment, construction, business, real estate, and insurance. He has been named as one of California's top 50 neutrals and is a frequent author and speaker on various topics related to mediation, negotiation, and other forms of dispute resolution. So without further ado, Monty and Mike, I'm passing it to you.
Thank you, Hayward, and thank you, ADR Services, for letting us make this presentation. Hayward, if you could move to the first case, Law Finance Group, please. There you go. Thank you. California courts publish about 500 cases every year. That's the Supreme Court Courts of Appeal. And so Mike and I are going to talk about several cases that are important new decisions. Now, with my California case summaries, my subscribers get monthly summaries, quarterly summaries, and every year an annual summary. And so these are examples, and we're going to rapidly go through some cases from last year. We'll start with the California Supreme Court. This first case is Law Finance Group, and this is a court case dealing with the time deadline for filing a petition to vacate an arbitration award or to oppose and seek to vacate an award after somebody sought to confirm it. Now, the general rule under both CCP 1288 and 1288.2 is you've got 100 days. And what happened in this case is the plaintiff, which was a lawsuit funding group, won at arbitration and got about $800,000, and they sought to confirm. And the lawyers, after the petition to confirm was filed, agreed to extend the time, but it ended up that the defendant filed much after the 100-day time limit. The trial court found that things were extended by tolling and equitable concepts. Court of Appeals said, no, the statute, the 100-day statute is jurisdictional, so you can't extend it. Supreme Court disagreed with the Court of Appeal, and the Supreme Court said, no, it's not jurisdictional. And even though the petition to vacate was untimely, it sent it back down to the trial court to consider whether under the tolling provisions, the Court of Appeal should consider whether under the tolling provisions it could be considered. So this was a significant ruling on the timing of trying to vacate an arbitration award. Let's go to the next slide for Mike.
Thank you. This is Cal Medical Association versus Aetna Health. Under the unfair competition law in California, private plaintiffs have standing to sue only if they've suffered injury in fact, and or they've lost money or property as a result of the business practice that they challenge. The California Medical Association here is a nonprofit organization that advocates on behalf of member physicians. It sued Aetna over Aetna's implementation of a network intervention policy whereby Aetna refused to pay for emergency services rendered by providers that were not within Aetna's network. The CMA alleged that the policy violated California's unfair competition law and that it had devoted more than 200 hours of staff time to responding to Aetna's network intervention policy. The trial court found that plaintiff CMA lacked standing because it had not lost money or property as a result of the policy, and the Court of Appeal affirmed. The Supreme Court of California reversed, holding that when an organization incurs costs responding to perceived unfair competition that threatens its bona fide pre-existing mission, and those costs are not litigation related, the organization has satisfied the unfair competition law's standing requirements and has standing to bring claims under the unfair competition law. Monty, turn it over to you on LA Unified School District. The next slide.
In this case, the Supreme Court looked at whether a school district could be liable for the treble damages allowed under CCP 340.1B1 for childhood sexual assault. And what the Supreme Court said is a school district cannot be liable because under Government Code Section 818, that section provides that public entities are not liable for punitive damages under Civil Code Section 3294, but it also has an additional phrase which says, or other damages imposed primarily for the sake of example and by way of punishing the defendant. And that's what they decided. This was that kind of damage. It was not compensatory damages, and the plaintiff could not get those damages against the school district. Let's go to the next slide for corporations.
Thank you, Monty. This is Turner versus Victoria. Plaintiff here was a director of a nonprofit charitable corporation, and she had brought suit against other directors under Corporations Code sections 5142, 5233, and 5223. Those statutes provide that a director of a nonprofit public benefit corporation may bring an action to remedy a breach of a charitable trust or to recover damages for self-dealing transactions by other directors and to remove any director guilty of malfeasance. After filing the suit, plaintiff lost her position as a director of the corporation. The trial court and the Court of Appeal here concluded the plaintiff no longer had standing to bring her action under those sections because she was no longer a director. The Supreme Court reversed, holding that the statutes in question do not require that a director plaintiff of a nonprofit corporation maintain her director position throughout litigation, and that she does have standing to bring those claims, even though she was no longer a director.
Next slide.
Next slide, please.
Okay, this deals with education, and each year there are numerous cases, normally in the courts of appeal, dealing with students who have been thrown out of school because they violated some policy, often policies against some kind of sexual assault. In this case, the petitioner had been a student and he was expelled from USC for violating its policy against intimate partner violence. And what he did is filed a petition for writ of administrative mandate, which the trial court denied, but the Court of Appeal granted it. And the Court of Appeal basically thought that he should be allowed to confront the complaining witness and other witnesses and cross-examine them, or at least submit questions to the adjudicating group and have them cross-examine. The California Supreme Court said, no, that's not necessary. They held that although private universities are required to comply with the common law doctrine of fair procedure by providing accused students with notice of the charges and a meaningful opportunity to be heard, they are not required to provide accused students with the opportunity to directly or indirectly cross-examine the accuser and other witnesses at a live hearing with the accused student in attendance, either in person or remotely. Let's go to the next slide, please.
Adolph versus Uber Technologies. This is an employment decision that has long been awaited for in California to finalize the rule as to who has standing and what is that standing to pursue PAGA claims on behalf of other employees. For those who do not do employment law, PAGA is a private attorneys general statute which allows an employee who is aggrieved under the statute to file an action similar to a class action on behalf of other similarly aggrieved employees who have suffered various wage and hour violations. Here, plaintiff alleged that he had been misclassified as an independent contractor and filed a claim under the private attorney general's or PAGA statute. The defendant employer moved to compel arbitration of plaintiff's PAGA claim on the ground that there was a valid arbitration agreement requiring him to individually arbitrate his claims against the defendant. The trial court denied the motion to compel based on existing California law as set forth in Iskanian versus CLS Transport of Los Angeles, that PAGA claims are not subject to arbitration, and the Court of Appeal affirmed that decision. While the defendant's petition for review was pending before the California Supreme Court, the U.S. Supreme Court issued its decision in Viking River Cruises, which held that the Federal Arbitration Act preempts the relevant portions of Iskanian and that individual PAGA claims could be compelled to arbitration. Viking River also concluded, based on its own analysis of California law, that a plaintiff lacks statutory standing to litigate his non-individual PAGA claims, his representative claims on behalf of other employees, once his individual PAGA claim has been compelled to arbitration. The California Supreme Court granted review to clarify state law as to whether an aggrieved employee who was compelled to arbitrate an individual PAGA claim loses his statutory standing to litigate non-individual PAGA claims on behalf of other employees. And the Supreme Court held that it doesn't. Where a plaintiff has brought a PAGA action comprising of both individual and non-individual claims, an order compelling arbitration of the individual claims does not strip the plaintiff of standing as an aggrieved employee to litigate non-individual PAGA claims on behalf of other employees. Now, this case has several implications. The court suggested that trial courts could stay the non-individual PAGA claims pending arbitration of the individual claim, and that the named plaintiffs would lose standing if they were unsuccessful in arbitration, and the arbitration award was confirmed as a judgment. Specifically, the court acknowledged that if the arbitrator determines that the plaintiff is not an aggrieved employee for the purposes of the individual PAGA claims, and the court confirms that determination and reduces it to a final judgment, the court should then give effect to that finding and dismiss the plaintiff's non-individual PAGA claims for lack of standings. And I think one of the lessons of this case is that attorneys might consider how they draft their arbitration agreements. Some writers suggest that drafting an arbitration agreement that mandates a stay of the non-individual claims pending the outcome of the arbitration might be enforceable. Another interesting thing, since this case was decided just a few days ago, on the 12th of this month, the Ninth Circuit Court of Appeals, in a case called Johnson versus Lowe's, upheld a decision ordering the Lowe's employees' individual PAGA claims to arbitration and vacating the district court's dismissal of the non-individual PAGA claims based on the arbitration clause. So it looks like this case, Adolph, as interpreted by the Ninth Circuit, now means what the California Supreme Court said. Individual PAGA claims go to arbitration, but that doesn't mean that individual loses their right to pursue representative PAGA claims on behalf of others under the statute.
All right, let's go to the next slide. And we'll try to quickly keep going through these cases. So this is another employment case, Kusimba versus Victory Woodworks. Occasionally, the Ninth Circuit will ask the California Supreme Court for an opinion on what California law is when something is pending in the federal courts in the Ninth Circuit. And that's what happened in this case. The Ninth Circuit asked two questions of the California Supreme Court. A worker had gotten exposed to COVID when he was forced to work with workers who'd been exposed. And then his wife got sick, and she was actually on the hospital in a respirator for quite a while, and they sued. And the question that came up, the two questions to the court is, if an employee gets COVID-19 at the workplace, brings it home to the spouse, is the Workers' Compensation Act in California a bar to the spouse's claim against the employer? And the second question was, does an employer owe a duty of care under California law to prevent the spread of COVID-19 to household members? And the answer to the question one by the Supreme Court was no, workers' comp is not a bar. It's normally an exclusive remedy for the injured worker, but the wife's claim was not derivative, and so it's a separate claim in her own right. But on the issue of duty, the Supreme Court said there is no duty by the employer. Employing the Roland v. Christian analysis, it found that there were a lot of foreseeability factors that might favor duty, but under a policy analysis, they said, no, we're not going to impose a duty. So let's go to the next slide here, another employment case.
Okay. Raines versus U.S. HealthWorks. Here, plaintiffs filed a class action alleging claims under FEHA, the Fair Employment and Housing Act, among others. Plaintiffs named the defendant, who was acting as an agent for the plaintiff's prospective employers. The district court dismissed all claims, concluding, as relevant to this appeal, that FEHA does not impose liability on the agents of a plaintiff's employer. The federal district court certified a question of law to the Supreme Court for determination. And the California Supreme Court held that an employer's business entity agents can be held directly liable under FEHA for employment discrimination in appropriate circumstances when the business entity agent has at least 5 employees and carries out activities that are regulated by FEHA on behalf of the employer. Next slide.
In this slide, we go to an evidence case arising from a sexual abuse case. In this case, the plaintiff sued the school district for sexual abuse by a 4th grade teacher, and the defendant sought to bring into evidence a later molestation several years later, which impacted the plaintiff as well and caused some of her emotional distress and related damages, allegedly. So that goes to causation. Now, the trial court heard in limine these issues and decided the evidence the defendant wanted to bring in was going to be admissible. Both sides gave opening statements, made reference to the later molestation, and even 4 witnesses testified. And then after that, the plaintiff had petitioned the Supreme Court, and they granted a stay. And so in looking at this issue, the Supreme Court's looking at Evidence Code Section 1106 that deals with admissibility of other sexual conduct. And even though subsection A says you can't talk about that, subsection E does allow the admission of other conduct to challenge the credibility of the plaintiff as provided in Evidence Code Section 783. And then, of course, there's a procedure for doing that under 783. And then the court also has to evaluate things under 352. Now, the Supreme Court concluded the trial court did not conduct a proper hearing under 783. It didn't hold a robust hearing out of the presence of the jury and allow questioning of the plaintiff regarding the offer of proof by the defendant. It didn't make an order stating what evidence could be introduced by the defendant and the nature of the questions to be permitted. And it also should have done a more robust 352 analysis. So the Supreme Court basically said in the appropriate circumstances, this kind of other evidence might be allowable. And it sent it back down to look at this further. Let's go to the next slide.
County of Santa Clara versus Superior Court. This case deals with the extent of governmental immunity or government immunity and the need to comply with the Government Claims Act, Government Code Section 810. This is another emergency medical services reimbursement case. 2 hospitals who had rendered emergency medical services submitted reimbursement claims to the county who were enrolled because the patients were enrolled in the healthcare plan operated by the county. The hospitals had no contract with the county governing the rates payable for emergency services rendered to plan members. The hospitals billed the county for the emergency services rendered and brought suit for unpaid amounts under a provision of the Knox-Keene Act, which requires a healthcare service plan to reimburse medical providers for the reasonable and customary value of the emergency care. The trial court concluded that the hospitals could state a quantum merit claim against the county. The Court of Appeal reversed, finding that the county was immune from suit under the Government Claims Act general immunity provision of Government Code Section 815. The Supreme Court of California reversed, holding that the county was not immune from suit under the circumstances of this case. It explained that the Claims Act immunizes public entities only from tort claims seeking money damages. The court rejected the county's characterization of the hospital's quantum merit claim as a tort claim seeking money damages, and instead viewed the claim as seeking county compliance with the statutory duty of reimbursement, more of a contract type claim.
Okay, the next slide, we're dealing with the government code as well. In this case, Travis versus Brand. Near and dear to all attorneys' hearts is the ability to recover attorney's fees. And this case dealt with Government Code Section 91003. What happened, the plaintiffs sued the defendants who had been some supporters of a measure called Measure C that opposed a development project in Redondo Beach. They had a 5-day bench trial, the court found for the defendants. And then afterwards, the court awarded the defendants $896,000 and change in attorney's fees under Government Code Section 9103. Now, the California Supreme Court reversed the Court of Appeal, which had affirmed the trial court attorney fee award. And what the Supreme Court said is, in order to effectuate the purpose of encouraging private litigation of enforcing the Political Reform Act, it interpreted Government Code Section 91003 to impose an asymmetrical standard, which constrains the trial court's discretion to award attorney's fees to a prevailing defendant. So consistent with the standard adopted in similar contexts, like the enforcement of civil rights and FEHA claims, a prevailing defendant under the Political Reform Act should not be awarded fees and costs unless the court finds the action was objectively without foundation when brought, or that the plaintiff continued to litigate after it clearly became so. Let's go to the next slide and we'll deal with insurance.
All right. This is a lawsuit, Allied Premier Insurance versus United Financial Casualty Company, a lawsuit between two insurance companies to determine contribution rights following the settlement of a lawsuit by one carrier. This is a case that holding that a commercial auto insurance policy basically expires on the date that the policy says it expires. It says, the policy says what it says. The policy expires on a certain date. Under the California's Motor Carriers of Property Permit Act, that's a vehicle code section 34600 at SEC. A carrier is required to file a certificate of insurance with the DMV and to give certain notices of cancellation to the DMV when that policy terminates. Here, the insured was driving a truck covered by his then current policy when he collided with a car, killing its driver. The current insurance carrier for the negligent driver settled the wrongful death case for policy limits and then sued the former insurer, which is the defendant here, for declaratory relief, equitable contribution, equitable subrogation. It was $1 million settlement, and the plaintiff here was seeking half of that, $500,000, back from the previous carrier, claiming that the previous carrier's policy had remained in effect on the date of the collision because one of the defendant's cancellation notices to the DMV had been rejected by the DMV as incomplete. And the California Supreme Court held that the act does not require a commercial auto insurance policy to remain in effect indefinitely past its expiration date until the insurer cancels a certificate of insurance on file with the DMV. Now, I would just caution that you may read this policy as being, this case as being limited, maybe only to contribution apportionment cases between insurance carriers. There's also issues of equitable estoppel, et cetera, that may lie in cases whereby the insured is suing their own carrier. Next slide, Monty.
Now we're going to talk about the Public Resources Code, and this case illustrates that when voters vote for something, they don't have complete 100% power. This case arose from the County of Monterey, where the voters passed a Measure Z, and this was a local ordinance that banned oil and gas water injection and impoundment and the drilling of new and oil gas wells throughout the county. Now, the plaintiffs in this case were oil producers and other people who had mineral rights. And the Supreme Court, in looking at this, said that this is not going to stand because by providing that certain oil production methods could never be used by anyone anywhere in the county, Measure Z nullified and therefore contradicted Public Resources Code 3106, which mandates that the state shall supervise oil operation in a way that permits well operators to utilize all methods and practices. And therefore, this measure was preempted by Section 3106. Let's go to the next slide.
In Gantner versus PG&E, this arises basically, This is a case relating to the California wildfires. Here, PG&E, which was then which is now in bankruptcy, shut down its electrical grid to avoid the potential for a wildfire. And that led to widespread power blackouts throughout PG&E's service areas. These events are referred to as public safety power shutoffs, or PSPS, and are subject to various guidelines promulgated by the California Public Utilities Commission. The plaintiff filed a class action seeking $2.5 billion in damages on behalf of residents and business owners that were impacted by these blackouts. The plaintiffs allege that PG&E's negligent maintenance of its power grid for decades had forced PG&E to implement these PSPS events in the first instance, and that it was entitled to pursue these claims. The defendant argued that its decision to implement these PS events cannot result in liability when it is a necessary public safety measure. This case was tried, or this was argued in the bankruptcy court, where PG&E was then in a Chapter 11, and the bankruptcy court agreed with PG&E's position and dismissed the complaint. On appeal to the district court affirmed the dismissal. The plaintiff then appealed to the Ninth Circuit Court of Appeals, which in turn submitted several questions to the California law to the California Supreme Court for determination. And the Supreme Court of California unanimously held that a plaintiff's class action lawsuit against defendant for damages related to public safety power shutoffs was barred by Public Utilities Code because it would impermissibly interfere with the California Public Utilities Commission's regulations of utilities PSPS programs. Another case of preemption.
Let's go to the next case, torts case. In this case, Leon versus the County of Riverside. Once again, the California Supreme Court was dealing with governmental immunity. Now, in this case, the plaintiff was a widow whose husband had been shot and killed by a neighbor. And basically, the trial court had granted defendant's motion for summary judgment in plaintiff's action. She'd sued for emotional distress as a result of the sheriff deputies dragging her deceased husband's body behind a truck, causing his pants to be pulled down and exposing his genitals, and leaving the body uncovered for about 8 hours while officers searched for the shooter and then investigated the shooting. What the trial court and the Court of Appeal decided is that the immunity in Government Code Section 821.6 protected the defendants. And that immunity deals with instituting or prosecuting any judicial or administrative proceeding. The Supreme Court disagreed when it got to them, and they basically said, no, Government Code 821.6 does not immunize police officers or others regarding crime investigations, because it's really not instituting or prosecuting a judicial or administrative proceeding. Let's go to the next case, another torts case.
10 Savati versus City of Rancho Palos Verdes. I think I butchered the plaintiff's name. This was a case that arose when a bicycle rider was killed by a truck making a turn in an intersection that the decedent's mother, who had filed a wrongful death case, alleged was a dangerous condition. And the city raised the fact that it was not liable due to design immunity under Cameron versus State of California, which was a Supreme Court decision. But the Court of Appeal, the trial court and the Court of Appeal held that design immunity does not preclude liability under a theory of failure to warn of a dangerous condition when the government entities are on notice that a reasonably approved design presents a danger to the public. So here, the Court of Appeal disagreed with the trial court and it found that Cameron could still be liable, it found that the defendant could still be liable for failing to warn of the dangerous condition. And there was nothing illogical in Cameron's conclusion that Government Code Section 830.6 was not intended to allow government entities to remain silent when they have noticed that a reasonably approved design presents a danger to the public.
Next slide. Let's go to the next slide, which deals with arbitration. And now we're starting into the courts of appeal. And this first case deals with arbitration and employment and also settlement and releases. In this Costello case, the Court of Appeal affirmed the trial court's order that denied a motion to vacate an arbitration award and its judgment confirming the award. Now, plaintiff sued her former employer for wrongful termination and age discrimination in violation of FEHA. The case was sent to binding arbitration under the stipulation of the parties, and the arbitrator granted defendant's motion for summary judgment on the basis that the plaintiff's claims were barred by a release in her separation agreement. The Court of Appeal concluded that the arbitrator correctly ruled the release did not violate Civil Code Section 1668, which limits certain kinds of releases. The plaintiff signed the separation agreement after she was informed of the decision to terminate her, but before her last day on the job. And at the time she signed the separation agreement, she already believed that the decision to terminate her was based on age discrimination and that she had a valid claim for wrongful termination. So in that circumstance, Court of Appeal said this release is valid and it upheld it. Let's go to the next slide.
This is an arbitration case, an employment case, Subject versus Skyview Capital. And the basic bottom line rule is employers, you've got to pay your arbitration fees on time, or the plaintiff is entitled to withdraw. As part of the arbitration process here, the defendant employer was required to pay arbitration fees on a certain date, June 4th, 2021. However, the company failed to do so. The arbitrator then set a new deadline of July 14th for fee payments, and the defendant eventually did pay the fees prior to the new deadline. However, the employee elected to withdraw from the arbitration under CCP 1281.98, claiming that the employer was a material breach of the arbitration agreement by not paying the fees as originally set in the arbitration proceeding. The Court of Appeal held that the arbitrator cannot cure a missed or late arbitration fee payment. If the fees are not paid on time, a party is entitled to withdraw from arbitration under 1281.98. So not only does this ruling confirm the importance of paying arbitration fees on time, but it also demonstrates the court's willingness to limit the power of an arbitrator over their own proceedings. Now, more employers must be acutely attentive to the arbitration fee deadlines to avoid costly court litigation due to their failure to pay on time.
So this case is a warning to all employers that if somebody is in arbitration because they've got an enforceable agreement, you sure as heck better pay your costs immediately and on time. Let's go to the next slide. This is a case dealing with attorney's fees, once again near and dear to all attorneys' hearts. And in this case, the Court of Appeal affirmed the trial court's order awarding plaintiff attorney's fees of over $27,000 for enforcing a judgment under CCP 695.0808. Now, defendant never answered the complaint. Plaintiff's got a default judgment for over $59,000 in an action alleging breach of a written contract regarding rental of the plaintiff's home. The default judgment included a 1,000 attorney's fee provision, and that's what it was limited to. So it couldn't exceed 1,000. Now on appeal, the defendant said, well, wait. The attorney's fees for enforcing the judgment should also be limited to 1,000 because of the contract. Court of Appeal said nope, and it affirmed the trial court's award because it concluded that once the judgment was entered, the terms of the written agreement, including the 1,000 limitation on fees, were merged into and extinguished by the judgment. And because the judgment included an award of attorney's fees authorized by contract, then Section 685.040 allowed an award of the reasonable attorney's fees. Let's go to the next slide, and I'm going to talk about this one as well. And this is an attorney fee provision that warns don't be a jerk in trial, because it'll come back to bite you in the butt. So in this case, the Sonek case, the plaintiff won, and the plaintiffs got an award of attorney's fees of $686,795.62. Now, the plaintiff won a jury trial and won damages of over $130,000 in his disability discrimination claim. Now, when the plaintiff asked for attorney's fees, they didn't ask for 686, they asked for over $2 million. The trial court applied a 0.4 negative multiplier to its 1.1 million adjusted lodestar to account for the plaintiff counsel's lack of civility throughout the entire course of the litigation. That's why its fee award was in the 600,000 range. And the Court of Appeals said, the trial court, it affirmed and said, trial court can consider an attorney's pervasive incivility in determining the reasonableness of the requested fees, and may apply in its discretion a positive or negative multiplier to adjust the lodestar calculation. So don't be a jerk, and it can pay you. It can be a penalty if you are. Go ahead to the next slide, please.
Thank you. In Grayott versus Bank of Stockton, this is an action under the Consumer Legal Remedies Act and related causes of action for misrepresentation. The plaintiff purchased a used vehicle from a car dealership with a contract that was later assigned to the defendant, who was the financing bank. And the contract included the FTC's holder rule notice, which basically allows a consumer to assert against a third-party creditor all claims and defenses that could be asserted against the seller of the automobile. And plaintiff sought to hold the bank responsible for refunding the money that he had paid under the contract under the holder provision in the contract. The defendant bank argued that it could not be held responsible because it was no longer the holder of the contract and had reassigned the contract back to the dealership and reimbursed the dealership for all monies it had received from the plaintiff. The trial court granted summary judgment in favor of the bank, the financing bank, accepting its argument. The Court of Appeals reversed, finding that a creditor cannot avoid potential liability for claims that arose when it was the holder of the contract by later reassigning the contract and returning monies received. I believe that it's not unusual to see when one of these Consumer Legal Remedies Act case is filed that some finance companies will try to bail by reassigning the contract back to the dealership. In this case, court said that isn't going to work.
Let's go to the next slide. And now we're going to deal with the civil code. In California, you can file a claim under the UNRRA Civil Rights Act, which is Civil Code Section 51, for ADA violations. And the ADA is federal legislation, Americans with Disabilities Act, but it's enforceable also under California law. And one of the things that's been happening in the last few years is there have been some published opinions dealing with whether somebody could bring a claim under the ADA for something like access to the website of the business. In this case, the Court of Appeal made what I think could be a significant decision if it's allowed to stay. And it, in this case, affirmed the trial court's order sustaining defendant's demurrer without leave to amend to plaintiff's complaint, alleging that blind plaintiffs suffered disability discrimination under the Onerous Civil Rights Act and the ADA because of the defendant's websites discriminated against them by being incompatible with screen reading software. And what happened is the trial court concluded that a website was not a place of public accommodation under the ADA. And the Court of Appeal agreed. The Court of Appeal concluded that the ADA unambiguously applies only to physical places. So if this ruling ends up being the standing law, that's going to limit claims that might be made against websites in the future. Let's go to the next slide, please.
Glassman versus Safeco was an uninsured motorist claim. In this particular case, the umbrella policy in question had a policy limit of $1 million. The plaintiff had made a policy limits demand and then had served a 998 offer for $999,999.99. The plaintiff won the uninsured motorist arbitration and was awarded the $1 million policy limits. The plaintiff then sought prejudgment interest going back to the date that the 998 offer had been served. And to obtain prejudgment interest, first of all, the court found that in these proceedings, prejudgment interest is governed by Section 3287A and not 3291, and that to obtain prejudgment interest, the plaintiff had to show that she was entitled to recover damages certain or capable of made certain by calculation, or the right to recover was vested on a particular date, and the defendant knew or was able to calculate from reasonably available information the amount of plaintiff's liquidated claim owed as of that particular date. But here, the trial court properly denied, or at least the appellate court found that the trial court properly denied plaintiff's request for a liquidated claim owed as a particular date. It says just because there had been a 998 offer filed, that didn't change the fact that the value of that claim, potential judgment, was not certain or capable of being made certain as of the date of the 998 offer. So they refused, and the court upheld it prejudgment interest from that date.
Let's go to the next slide with another civil procedure case, and this is Pabla versus Superior Court. This case deals with an order for preference. So in this case, a party, the plaintiff, filed a motion for preference under CCP 36. Her declaration said she was 73 years old, suffered from asthma and hypertension, had recently undergone kidney surgery, and was receiving dialysis. Now, the defendants didn't really object to any of those things, but they raised concerns about completing discovery and pretrial motions under an accelerated schedule. And the trial court ended up granting the motion for preference, but set the trial court for 1 year after the motion was granted. Court of Appeals said, nope, can't do that. And it granted a peremptory writ of mandate directing the trial court to schedule a trial within 120 days as required by CCP 36. And the Court of Appeals said, having granted the preference, superior courts have no discretion to avoid the command of Section 36 in the interest of efficient management of the court's docket as a whole. Let's go to the next slide, please.
I believe this is pronounced Arce versus Ensign Group, Inc. In this case, the plaintiff filed various PAGA claims, private attorney general claims, against her employer after she was terminated. At termination, she was paid for her accrued vacation time and the hours that she had worked during her last pay period. And she received wage statements for these payments, but neither contained premium wages for missed meal or rest breaks. Approximately a year after her termination, plaintiff filed her pre-filing PAGA notice with the California Labor and Workforce Development Agency and subsequently filed her PAGA lawsuit. The trial court granted summary judgment against plaintiff, finding that she was unable to show that she had suffered any labor code violations during the 1-year limitations period prior to her PAGA notice and thus lacked standing to pursue her PAGA claims. The Court of Appeal here reversed and it ruled that it's not sufficient to negate, this was not sufficient to negate standing. The court said the plaintiff was entitled to the requisite meal and rest breaks. And for any day the plaintiff's employer failed to provide a break, it was required to compensate her with 1 hour of premium pay. All unpaid premiums were wages due. Thus, any overdue premiums were required to have been paid on the date of her separation and was required to be shown on her final wage statement. Even outstanding wages that the employer failed to pay as part of this wage statement constituted its own labor code violation, each of which fell within the limitations period. So the California appellate court here was clear. It's not enough for the employer to show the plaintiff had not been denied meal or rest breaks during the year before she submits her PAGA notice. The employer must also establish that the plaintiff has been paid all outstanding meal and rest break premium pay either before or after her termination.
Let's go to the next slide, please. This is another employment case, and in this case, the plaintiffs brought a class action alleging that defendants, including the Walt Disney Company, were required to pay living wages pursuant to a municipal ordinance in Anaheim, which applied to hospitality workers in Anaheim or Disneyland resort areas. Now, the trial court granted defendants' motion for summary judgment because they agreed with the argument of defendants that, well, we don't have any kind of a special deal or subsidy. And that's what they said. You only have to comply with this if you benefit from a city subsidy. The Court of Appeal looked at the case. They said, no, that's not right. And they reversed. They concluded that Disney entities had a lot of agreements, an infrastructure and parking finance agreement, a Disney credit enhancement agreement, and a reimbursement agreement. And the Court of Appeal looked at the reimbursement and they said that agreement gave Disney the right to receive a rebate or a return of transient occupancy taxes paid by the hotel guests, sales taxes paid by consumers, and property taxes paid by Disney in any rebound years when the city's tax revenues were enough to meet its bond obligations. And therefore, this was a city subsidy. So Disney entities did have to comply with the living wage ordinance. Let's go next to the next case, please, an evidence case. This is the LAOSD asbestos cases. This is a important case dealing with a corporate witness. In this case, the Court of Appeal reversed the trial court's order that it granted defendant Avon Products motion for summary judgment against the plaintiffs. Alicia Ramirez had died from mesothelioma, and she and her husband brought the action. She died while the appeal was pending. And defendant's motion for summary judgment relied upon a declaration from Lisa Gallo, who's an employee. And she only began to work at Avon about halfway through the decedent's alleged exposure period. So defendant filed this declaration from her, and plaintiffs objected to the declaration and attached exhibits on the grounds they lack foundation, lack personal knowledge, and contain hearsay. Trial court overruled those objections, granted summary judgment based primarily on the declaration, and said the burden was shifted to the plaintiffs to produce evidence enough to create a tribal issue of fact. Court of Appeal disagreed with that evidentiary ruling. And it basically said, look, the trial court erred in overruling the objections based on lack of foundation, lack of personal knowledge, and hearsay nature of the documents. Because Lisa Gallo was a lay witness, not an expert witness, she was limited to testimony reflecting her personal knowledge and could not testify to hearsay. So there's no special category of some kind of a corporate representative witness. This case could present some interesting questions because, as you know, a corporate designated witness can bind the corporation in what he or she says on issues. But on the other hand, they may not have sufficient information to pass objections, as happened in this case. Let's go to the next case, Mike, and talk about real property.
All right. Rydick versus Hinkle. This is a horrible situation. Basically, the proverbial little old lady from Pasadena was scammed out of her home. The facts are just terrible. But it basically involves the validity of a deed of trust securing a loan. A party that obtained title to the home obtained a quiet title judgment that was later declared void. But while that judgment was in fact a third-party lender loaned money to the purported owner and secured by a deed of trust on the property. The lawsuit sought to invalidate that deed of trust. And basically the court held that a party who relies on a quiet title judgment when subsequently acquiring rights in the property retains those rights, even if the quiet title judgment is later invalidated, so long as that person obtained their rights without actual or constructive knowledge of any defects or irregularities in the quiet title judgment or the proceedings.
Yeah, I think what's interesting in that, Mike, is Court of Appeal said trial court can't ignore the rules of the statute if it doesn't like the outcome. Let's go to the
That
next.
goes without saying, yeah.
Let's go to the next thing. And we're almost at the end, but we've got two more cases, and I think we're going to land right on time here. So this next case is Brancati. And what this is a case where there was a mold injury and plaintiff was suing for personal injuries due to toxic mold exposure. Now, she retained a doctor as her expert, a Dr. Simon, who is board certified in allergy and immunology, and he did examine the plaintiff. He made a differential diagnosis that the mold in the house caused a respiratory illness. He eliminated a couple of potential causes. He also was a scientific researcher, and he had conducted a peer-reviewed study about mold and its environment on health. And the trial court concluded he was not qualified to testify despite all of these factors. And the Court of Appeal disagreed. And they disagreed saying, no, I mean, he was a doctor and he could make an appropriate differential diagnosis, which he did. And on top of that, he had the scientific research qualification. So for both of those reasons, that was an error. Let's go to this next tort case, which is our last one, Mike.
Thank you. Gutierrez versus Tostado. The lesson in this case is be careful in thinking that a case is a normal PI case subject to a 2-year statute of limitations. Here, the plaintiff was rear-ended by an ambulance driver who was transporting a patient between medical facilities. Nearly 2 years later, the plaintiff sued for negligence, and the defendant moved for summary judgment on the ground that the plaintiff's claims were barred by the 1-year statute of limitations of Micro. The trial court granted that motion and plaintiff appealed. And on a split decision, the Court of Appeal affirmed. It held that the Micro limitations period barred plaintiff's negligence claim because the defendant was a medical provider rendering professional services at the time of the accident. The court stated that Micro applies to any negligent act or omission by a healthcare provider in rendering of professional services. Micro applied because plaintiff was injured by the defendant's alleged negligent driving of an ambulance transporting a patient. And transporting a patient in an ambulance qualifies as a provision or providing of medical care, and driving the ambulance is an integral part of that care. Moreover, the fact that the plaintiff was a third party who was not receiving medical care was irrelevant because Micro is not limited to lawsuits by patients or recipients of the medical services. The majority reasoned that it would be anomalous if different limitations of periods applied to patient and third parties who were both injured in the same accident.
So Mike, thanks for all your help today. Hayward and ADR, thanks for letting us do this. One final comment. If you like these short 1-paragraph summaries, you can join and become a subscriber. It'll help you keep up all the time with the new cases in your practice areas, give you a competitive advantage, help you win more. So thanks very much for joining us today. Thank you, Hayward.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.